Recording in progress.
Okay, we will call to order the June 21st regular meeting of APCHA. Cindy, would you please take roll?
Yes. John Doyle.
Here.
Ward Howenstein. Stein.
Present.
Kelly. Here. John Ward.
Present.
Carson.
Here.
And Allison's not here, and Francie's not here yet. Francie's not going to be here.
Okay, great. First item on the agenda here is public comment. So we will have public comment, 3-minute time limit for public comment. Just as a reminder, we do have a couple of hearings on the agenda today, and would just make the comment here regarding the two appeals that we're not going to be taking public comment on either of those appeals. All of those decisions will be based on the record, which has already been closed, and the time to public comment on those has passed. So with that, if there is public comment, 3 minutes. Peter, if you want to go ahead and come on up. I think you may have to go.
Where would you like me?
See if that
Here?
mic is turned on, yeah.
Good, thanks. Hi, my name's Peter Fornell, for the record, and thanks for having me. And today I'm here with Alon Madero. I'm here this afternoon in my capacity as the president of the board of directors of the Clarendon Condominiums Homeowners Association. The Clarendon Condominiums Homeowners Association, as you all might or might not know, has one deed restricted unit on the premises. That deed restriction's been there since, I think, 1977 or something like that. Throughout all of its existence and the existence of Clarendon Condominiums, we've always used that deed restricted unit as a worker unit to manage our grounds, snow, grass, all of the above that goes along with maintaining a 15-unit vacation rental complex. And Alon does a great job, and he and his family live in that property. Alon, for a number of reasons, otherwise qualifies for the lottery and affordable housing. However, he's met up with some challenges with staff that I'm hoping that we can get some clarification or to help us maybe work out, and that is that we don't pay Alon for his services, and he does not pay rent to us. That's the working relationship that the unit's always had, and it's worked out really well. We've always had good people, including Alon, who's done a marvelous job for us for years. His family's growing, and he feels like it's time for him to start to try to get into the housing lottery and do the same thing as so many other lucky people have done. But we're hitting a roadblock with your staff, and I think that maybe you as a board might have a little more lateral authority to give direction to staff than maybe their capacity themselves, in that they don't consider volunteer work to go towards your $1,500 a year or whatever. I'm not going. We don't have to go through all the rules, but by no means is he a volunteer. And we're, what we're looking, I believe that we have possibly the only unit in town that operates this way. So for us to try to legislate a change in policy for what's likely a one-off situation, what we're hoping for as a membership and for the Madero family is some consideration be made for him to be considered as an employee so that he can prove all of his hours and all of those things. It's just that we're not exchanging money back and forth. And it's just not quite fitting through the pinhole of the qualification process. He works hard. He does a great job. I think that everyone at Clarendon is very proud of the fact that we have an affordable housing unit on our site and we house our staffing needs that way. So we really have a good product and we've got a good agenda going. But I'm hoping for you all to see the good sense in all of what it is that we're doing, and maybe give your staff some direction on a individual case-by-case basis, as opposed to trying to come up with a new rule or regulation for something that you know, in 35 years we haven't seen it at Clarendon condominiums, and it may or may not have come before you, and it may never not again. So we're hoping that you've got some assistance or relief for us in this little loophole that we have, and I'm hoping to hear your thought on that, Carson, or anyone.
Thanks, Peter. So I don't, Peter, this isn't really the venue for discussions on individual qualification, matters. I mean, this is something we can certainly have a discussion with staff on, but this really isn't the venue for an individual qualification discussion.
The closest solution that staff has been able to present thus far has been for us to pay him and him to pay us, and turn it into a situation that really doesn't work the best for anybody involved out there. Right. And we're at a bit of a stopping point with this, although again, right, he's years and years of service and hard work, and in my humble opinion, is well deserving of an opportunity to be part of our lottery system. So is there someone that you might have us work?
Carson?
Yeah, Cindy and I can talk to Maddie tomorrow. And
Yeah, I mean,
Paperwork,
yeah,
and we can look through it and see what's going on.
okay.
Can we ask that to be added to the next executive director's report at the next meeting?
the update on this specific case?
Yeah.
Sure.
Thanks, Kelly, and thanks to Bethany and Cindy and to all of you for your time, and hopefully we'll find a good resolution for a nice family.
Thank you.
All right, thanks, you guys. And should we expect Alon to make contact with you directly, or should you?
It's tomorrow's Thursday. It may not be until Friday or Monday.
Sure,
but
and if
by
it was
Monday
even
for
next
sure,
week,
we will get in contact with him by Monday for sure.
And you'll contact him, and
Yes.
so he'll expect to hear from you. All right, well, thanks, you guys. I really appreciate it. Have a nice day.
Thanks, Peter. Okay, any other public comment? If you're online and you would like to make public comment, please raise your hand. Okay, not seeing any public comment. We will close public comment and move to Board of Directors comments. And we will start with Allison.
Missed roll call, sorry about that. And I think that's all I have right now.
Kelly.
Yes, I am curious who our new member is. Do we have to swear them in at all?
I'm still trying to clarify with the city council if they've officially have appointed him, like the county has.
Yes.
Nobody's gotten back with me yet.
Okay.
I have been emailing back
But that was part
with,
of your meeting?
I have been emailing back, Peter Grenny has been appointed as the alternate member, community member for the board. He couldn't make today's meeting. He will definitely be at the retreat.
Okay.
Okay.
Thank you, I appreciate that. And then I just wanted to share, not everybody reads the paper every day, but there was a story today about a poll related to a potential housing tax for the county had directed. They've subsequently directed not going after a housing tax this year based on the polling results. I'm disappointed by that, but I understand the dynamics at play in 2023. And we'll hope for all of your support and advocacy in 2024. I did want to share that conversation, what was interesting about some of that conversation was out of 300 surveys that they did with people, they had 240 open-ended responses as in addition to answering the questions. And the polling an expert, the guy who ran it for us, so there was a lot of commentary about APCHA and concern about APCHA in those open-ended comments with relationship to people's attitudes related to housing in the community and whether a tax is appropriate right now. So I just wanted to share that. I have gotten the detailed responses, but I haven't gone through all of that, and I'm happy that's public information. I'm happy to share that with you all if you want to peruse over that feedback and we can talk. But it just continues, I think, to be part of our conversations as a board related to APCHA's reputation in the community and what we're doing, and myths that abound and get repeated frequently and have really taken, I think, hold. And some of our desire as a board to do more outreach, which we have been doing. But I think more of that work and more of that dedicated effort is something I think we should talk about during our retreat as well, which I assumed we would because it was sort of an ongoing topic of conversation for us. But I just wanted to let you all know that.
Thank you, Kelly.
Can I jump in?
Sure.
This might be a Tom Smith question, but that seems like the kind of thing where we'd want APCHA's board to have a recommendation or a request or a something kind of formal to submit in support, obviously, of affordable housing. And I feel like a couple of either proposals or things in front of H.P.C. or planning and zoning, things have come up. And I just don't know if, as a board, we're allowed to take a stance and give recommendations to, obviously, other members of our board who are the ones ultimately voting, like what the, how that works seamlessly, or if we as a board basically never get to say what we think or never get to encourage other governing bodies in this town to take action.
The question is, can you do that?
Yeah.
You can make recommendations.
And so our city council meeting could basically, our city council members could pre-approve something that then they vote on later.
That's a different question. I'd have to think about that one. The board as a whole, of course, can make recommendations to the city and the county or any other governmental agency through whatever the appropriate channels are. There is concern about board members who are elected officials prejudging a matter that's going to come before them. So we'd have to think about.
So those types of recommendations were neutered a little bit with the new board structure.
Yeah.
The land use reviews are done basically by staff and not brought to the board because of city council being on the board and Board of County Commissioners being on the board.
I would think that the
We have
board as a
all-
whole could take a position on something and individual members might elect to recuse, or abstain from that vote
Are you talking about in support of a tax?
or something, or a project.
A
or
new housing
policy
development,
or-
for instance.
Yeah.
Yeah, I think that you can take a stance, but if you can't lobby for, or as individual members, you can take a stance, but you can't lobby for it. And if you give any support in the form of dollars or in kind, you have to give it to both sides. I think.
It may be just that the board, the APCHA board member who's on the BOCC would refuse. It doesn't preclude the rest of the board from acting. But let me look into that a little bit. I know this has come up in the past. It came up at the time of the IGA because of that very concern about members of elected officials on this board voting on something that would come up later in their other capacity. So let me look at it and we'll see.
And that could be an info memo in a packet as well, thanks.
So,
And that reminds me, I think at one point I asked for an info memo, and I legitimately don't remember if it came through, kind of going over the RFP process for a current hearing officer, or if there's options for others. I feel like we hear frequently enough that it'd be good to have that for the record. How do we get the one we have? Are there options for asking for an alternate? And so again, just an info memo, mostly for the public, because it comes up here and there. So those are my things. Thank you.
Carson, it was provided. We can recirculate it, but it was
Okay.
provided months ago.
I have that
Okay.
gray memory of it. Thank you.
Board?
I'd like to thank Kelly for being the sole member of BOCC to support a tax. Lord knows we
Lonely
need,
over there.
yeah,
Pioneer.
we need as much funding as possible to address the workforce housing crisis. So I thank you for that. And I think that to your question about Peter Greeny, that I think there was a 3-2 polling in support of Peter being on the APCHA board as an alternate. And that those board appointments are normally just announced as a procedural thing at a city council meeting. Other than that, I have no comments.
Thank you, Ward. John Ward.
I don't know, this might get me in trouble, especially with the previous conversation. So, I appreciate the city council members on this board slowing down the lumberyard process a little bit. I think there's lots to be done before that process move forward. You know, my concerns deal with, we as a board have never really put any teeth behind our regulations and maintenance issues. Just to continue to build units that may or may not get maintained in a proper fashion is in my opinion irresponsible as an organization. So continuing to work on that and move that forward to ensure that HOAs are funded adequately, that individual owners are maintaining their units in a just manner, and they have some kind of pride of stewardship of our program to turn units over to the next owner. Maybe not the same, but as good, if not decent condition enough so we're not deteriorating housing. We still have that issue. Another point of that is I think the city is really giving a big middle finger to Down Valley, and everybody that comes up here and serves Aspen and takes care of Aspen, works at the ski company, works in the construction and industries, works in the service industry, if we don't deal with the entrance to Aspen. And that needs to be dealt with before we put any more housing outside the roundabout. My simple opinion.
I will bite my lip on replying to that.
Well, it needs to happen. It needs to be fixed. It's been,
Well, the
I've been here
ETA is gonna
23
take a
years,
long
and it's
time.
been 23 years and nowhere, so.
Yeah, the ETA entrance to Aspen is gonna take a long time to get a Castle Creek Bridge.
Sure, I know, but it
And
needs
they-
to.
those two are
by
related,
Postponing
but-
it makes no progress. Anyway.
Thanks,
Can
John.
can I say one thing and ask one thing
Sure.
related? Sorry. Did the city approve up to 10K in maintenance grants? Francine, I couldn't remember if that had been formalized
I
after.
thought that'd been approved.
The proposal came to the
I think I
county, we
saw it.
said, we'll see your 100 and raise you 100, and we want to do $10,000 grants rather than $5,000.
I think I saw that it was approved in the paper.
I believe so. I believe the city matched the county.
Yeah.
Okay. and
Well,
then-
we upped it by $1.
That actually was my request.
I'll give you your dollar. I will say, the county has some piles of money right now that are targeted towards housing that I'm personally pretty anxious to spend. One of them is for this year's budget. I feel like we should allocate it this year. Another is ARPA monies that, really were intended to kind of be like rapid response sort of dollars, which county's not been so rapid on. We still have time to allocate them, though. We're still within the boundaries. They have to be allocated by 2024. That our board has dedicated towards housing. So, maybe a conversation is at hand to talk about maintenance and make a funding request related to maintenance for the county. So I just want to throw that out there for potential conversations at the bar or future conversations at this board.
Good.
Thanks, Kelly. John Doyle.
Yeah, I have a comment and related to what John Ward brought up. My reason for continuing the lumberyard last week, and I think there was support for this on the board, was I brought up the fact that we have the lumberyard, the entrance to Aspen, and the airport all being talked about right now. They're all long-term projects. And they're all in close proximity to each other, and they all interact with each other. I think we should be looking at them comprehensively. That's the reason I voted to continue, because I think I have some questions that I want answered before I vote for it to go forward.
Well, it wasn't popular at the time. I made this comment about the lumberyard. But, you know, if you park it like any normal structure, you're gonna add traffic. This isn't a
That's common sense.
a commercial, I mean, this isn't a project where you ever worry about either selling or leasing it. Make it a model, make it a transit-oriented program. You're right there on the bus line. Don't park it. You know, have the units. Tell people they either have cars and they park them at the Brush Creek lot or somewhere else. And, you know, you still lease it, you still sell it, and you force people to take the bus, take public transit, which is readily available in that location.
John, we have had discussions along these lines over the 4 years we've been working on this, and the code requires a certain number of.
But you guys control the code.
What you're talking about, John, is social engineering, and that's
Sure.
what you're
That's what this
you're
whole program
asking.
is.
And by polling, 95% of the people that were potential people who live at lumberyard said that they need a car. And John brought up the subject, and there is Edward Oilman's. I think if he could give a demonstration or a presentation of his holistic approach to APCHA, that might put some seeds for thought. But I was hoping that we wouldn't have to talk about the lumberyard and the entrance to Aspen at APCHA, but.
Well, I think it's all, I mean, it's.
John, I'd be happy to have a beer with you or two and talk about
I
all
like
of
it.
these
It's
issues.
all connected.
Yeah.
It's all connected.
Okay, and you know, I mean, I will just piggyback on what John Ward said. I mean, I think that the capital reserve issue for new projects, I mean, I think that is absolutely something that we could tackle. I mean, I think that should be relatively straightforward. Probably would need some guidance from our attorneys on how to manage that. But you know, I know there have been projects in the past that are fully funded at the start, and then as time goes on, you know, there's either they rebate money back to the owners, or there's other things that happen that then put the association into financial hardship. So, you know, I would think that that's something that should be relatively easily to say, you know, we got to have a capital reserve study every X number of years, and you got to be funded at, you know, X% of the need. I mean, that should be relatively straightforward. I don't know how you control that going forward, and the owners could always just change that. So maybe you address it in the regulations. So,
Yeah.
but something definitely I think that merits additional discussion. Okay, with that, I've got the executive director updates. Next item. I'm not seeing Matthew online.
No,
so-
he's
On vacation.
yeah, he's
Good
on
for him.
vacation. And with regards to capital reserve, there is a group of city employees and APCHA employees that are working on this. We're coming up with ideas of what to do.
Right.
Require new development, and what can we do with the current one? So that is being worked on. And we just met on that yesterday. So there's a lot of work going in on that right now. So as soon as we have something that we can bring back to the board, we will.
Great.
Yeah, Matthew is on vacation. He's due back, I think, when the joint meeting is on the 18th. And then for the retreat. So he'll be back for the joint meeting on the 18th, and then for the retreat. So he's on vacation for a while. He's out of the country right now. Yeah.
Good for him.
Could we have a debrief of that, if the joint meetings first? So it'd be great. Some of our board members will have just had that meeting. I would love one of the agenda items, whoever's putting that together, to hear that, because, I mean, it could have gone the other way too, and then you guys would have had to bring all of what I have to say to the government officials, but maybe it'll be more smooth that direction. Thank you.
The joint meeting is being talked about with the Board of County Commissioners and City Council, not with us, so.
And then we'll have our.
Yeah,
Right.
happy to.
Evan Joseph, did you mute him? Okay, and Cindy, any available rental or sale units?
Did we add a sale unit, any sales unit this week? Okay. Next week. So there will be some next week. What about rental units? Not yet. So again, remember to sign up for notifications on our website. And if anything that comes up with regards to what we manage, we'll have that on there. It'll tell you how to sign up for it, and we can go from there. We are having better luck in filling some of the T2 units since the incomes went up quite a bit. So that has helped us a lot when the incomes were increased.
Great, thank you. Okay, next item is the consent calendar. Sole item, minutes of the June 7th, 2023 regular meeting.
I'll move to approve.
I have a motion to approve from John Ward. Is there a second?
I'll second.
Second from Ward, and roll call vote.
Okay. John Ward,
Yes.
Carson,
Yes.
Ward Hallenstein,
Yes.
Kelly,
I'm going to abstain since I missed the meeting.
okay, and Allison.
Yes.
Motion passes. Okay, we will move to the final disposition on the appeal of Highlands Villas LLC from findings of fact, conclusions of law, and ruling of APCHA hearing officer dated January 20th, 2023. So with this,
I just want to make a comment that I listened to all of the hearing and read the record and was updated by Francie about executive session discussions.
thank you, Kelly. And so with this, in the packet, Tom has drafted a couple of, I guess, what are they? Resolutions for us, Tom.
Yeah, I'll
Do you
just,
want to just quickly
yeah.
touch on those, and then
Okay,
we can
to bring
deliberate?
everyone up to date, this was a matter that was heard by the hearing officer, decision made upholding an NOV that had been issued against Highland Villas LLC. It was appealed to this board. At the last meeting, the board heard the record's closed. At the last meeting, the board heard the arguments of and position statements of the APCHA staff and Highlands Villas LLC and MAA as the affected third party. The board concluded the oral arguments but didn't begin its deliberations. And the purpose of this meeting is for you to have those deliberations because there are unusually more complex questions of law presented by the appeal. I took the liberty of preparing two potential resolutions, one going one way, one going the other. And it's up to you to decide what you want to do. Those drafts, you can ignore them, you can change them, you can do whatever you want with them, but I thought that would be a way to get the deliberation started and present you with some different ideas. But it's your call, and you're ready to deliberate, and that's about all I can say at this point.
Thank you, Tom. All right, who wants to kick us off?
You know, after listening to the discussion or points last week, you know, I was going to move quickly on this, keep it moving forward. I think it's a pretty clear decision here in relation to the units and the restriction on the lease. But I would move, I'll motion to affirm the ruling of the APCHA hearing officer dated January 20th of 2023 in regards to the Music Associates of Aspen and the Highlands Villas property owner.
Okay, I have a motion from John. Is there a second or additional discussion?
Well, I'll second for additional discussion.
Okay, so we have a second.
I would advise you to have some
Before we-
discussions for
yeah,
the
before we
record on
vote,
that. Yeah.
Kelly, Allison,
Oh.
Ward.
Okay. I will say, I'm probably more familiar with how these things go a little bit than maybe the APCHA board, or maybe except for John, who's done these for many years, because the BOCC does get our own appeals of hearing officer decisions. And yes, I did listen to the whole meeting and read the whole record. I think the motion is appropriate. You know, the court cases resulting in what is due MMA seemed pretty clear, you know, are clear, and that the MMA had the option of requesting a longer lease term is MMA's choice to pursue or not pursue, and the deed restriction says that the units could be leased in May and September, did not say that those leases had to run to MMA. They couldn't be leased to other parties or to the winter seasonals. So, you know, I do think that the findings are appropriate and that there was not an abuse of discretion applied in this case.
Well, you know, I think Jody's a good attorney, and Jody had a good argument. But I think there's clear duress. I think we've all talked about it. Ward just used the term crisis at one point in the meeting today. We've all went to a housing summit probably 2 or 3 months ago in March that talked about the dire need for housing. I think the music school, the music associates had, you know, they had real concern, and they signed the lease under duress. They stated they signed the lease under duress, but they needed to lock up housing for people. And so they did that. I think this was a violation of the deed restriction that had been already determined once. Was it 2009? I can't remember the date now. The details, it's been 3 weeks, but to me, this is a clear and easy decision for the case officer, and to back up with his decision.
I think that there was a clear condition put on the exercise of the deed restriction, which says from may rent from June to August. And there was an additional restriction put on, I think, adding on parts of April and September, or May and September, and that is the deed restriction follows the property regardless of the sale of the property. So it's in place, and I think that the time constraints put on MAA acted as duress or pressure on MAA. MAA did sign the lease, and in the process in their email noted that they were not, by signing this lease, agreeing that the extended lease was agreed upon by MAA. Those are the major points that I base my decisions on.
Yeah, I mean, I will say I'm in agreement. I'm supportive of the motion. You know, I had 4 points here just on you know, the lease is from May 5 to September 25th. I didn't see any negotiation. There was a mention of inflation and costs, including HOA dues. To me, that was very clear for what the motive was. And, you know, we could make an exception to let you drop out, and then Music Associates Aspen, when they signed the lease on the 27th, you know, stating in the email that they were signing the lease. I mean, anybody, I think, who has tried to get housing in this valley understands that it's difficult, and trying to move from April to June to find housing is very difficult. So I'm supportive of the motion. Any other discussion or move to a vote?
Yeah, I think our main task is to look at the deed restriction and, you know, keep those who are part of the program to those. And so I agree with what's been said about what's in the deed and then what was kind of demanded outside of that, and that's what we're most concerned about. I think the issue of duress is what it came down to legally, and you know, that there's an outside of APCHA, other courts as well, who have different opinions about that. But I think the duress was stated clearly actually by both parties. I think Highlands Villas also mentioned in their discussion how hard it is to find new people when they kind of said you got to go now or else we're not going to find new people, and how tight the situation, especially at the time, was. But also, there's this argument that the threat doesn't count as duress if the victim fails to pursue a reasonable alternative, but yields to the threat. And to me, the fact that we're here right now shows that the victim has sought other alternatives, including getting lawyers and asking for the notice of violation and continuing it to here. So to me, yeah, it's kind of the arguments. We've kind of gone through them point by point, and I find John's motion acceptable.
I have a question if the board wants to comment on item 4 on the order, which is the $30,000 fine.
And so that number is a fine of, that is the fine schedule. The fine schedule dictates it's $5,000 fine, $5,000 to $6,000 fine, correct? And there were 6 units, and so it is 6 units and a $5,000 fine per the existing fine schedule.
Yeah, I understand how it's calculated.
Yep.
But I want to know if there's any comments from other members of the board on if it should be calculated as 1 or 6, and if the $30K is an amount that the board feels is appropriate.
I think we spent legal fees on this that we don't get back. Tom Schmitz time, whatever else. You know, I'm a guy that's willing to put deals together and be, you know, try to get the deal together. I think that's the fine. That's our fine. That's what we put in place, and it was violated.
And I guess I'll just comment that because this had been adjudicated in court years prior, you know, this is sort of a revisitation, like, of a question that, you know, I think should have been settled. So a violation in the context of that history, to me, is different than sort of a first blush violation, I would say.
And I agree. I mean, I think I think the fine is appropriate. I mean, you know, the purpose of implementing the fine schedule was that you know, so that we didn't have to force the sale of units in circumstances where there was a violation of the rules. And I think, you know, it's 6 units. You know, I think the fine is appropriate.
Thank you for the board for weighing in on that.
And so with that, if there's no further discussion, we will move to a roll call vote.
Are you voting on the resolution?
And we are voting on John's.
Pages 8 through
I'm
18.
going to restate my
Would
motion.
you restate your motion, please?
I move to, I guess, affirm the resolution of the Pitkin County Housing Authority Board denying the appeal of the Highlands Villa LLC and affirming the ruling of the APCHA hearing officer dated January 20th, 2023.
There are some
Resolution number 5,
typos,
series
there
of
are some
2023.
typos in there that I'll fix, okay?
That's what Grammarly's for.
Scrivener errors.
Do you second again?
Oh, second, I thought.
Thank you,
we
Ward.
were-
Die.
All right, Cindy?
Okay. John Ward,
Yes.
Carson,
Yes.
Ward Howenstein,
Yes.
Kelly,
Yes.
and Allison.
Yes.
Okay. All right, the
Thanks,
motion
Jody.
passes, so we will move to, let's see, we will move to the next item on the agenda. We've got an executive session here for conference. So this item is here as an agenda item if the board needs it. So
I don't know who's who around here.
So we go into executive here, or what do we do?
Well, that's actually a question for the board. My understanding was that was actually put on the agenda and was a sort of a repeat from a prior agenda. It's really up to you if you have legal questions or seek legal advice concerning the project of the next, the process. Really, oh, I'm so sorry. My name is Kate Johnson. I am with the city attorney's office. The city attorney's office has been asked to serve as legal counsel to the board because Mr. Smith will be representing staff in this case.
I would love to move in. Should I motion to?
please.
I'd like to make a motion to move into executive session briefly for a conference with our attorney. Should I say APCHA attorney? For the purpose of receiving legal advice under C.R.S. section 24-6-4024B regarding David Singer's appeal to the APCHA Board, appealing the hearing officer's written decision regarding Dr. David Singer's lease termination, please.
Okay, so we have a motion to move into executive session.
One second.
And a second
Can
from
we
Kelly.
discuss that real quick? Feels like it wouldn't hurt to listen and then go into executive session after, like the order is out of whack.
So just to kind of give you some frame of reference of why.
Well, shouldn't Tom be the?
You can vote no, I guess, on
You can
this,
vote no,
but
and the other thing too, John, is, I mean, if you have the option to do both, right? So I mean, if
We
you
go
listen
back
to
in,
it and
okay.
then you need to go back in, you can
Okay.
you can do that as well. So we got a motion right now, and so we'll vote on the motion to go into executive session.
Okay. Allison,
yes.
Kelly,
Yes, with a comment. So does our board need to consider whether APCHA staff and Tom Smith join us in this
gonna
or
be in it.
invite us?
I'm not in it.
Okay,
I just want this attorney.
got it.
Thanks.
Yeah.
Okay.
thank you. Ward
Yes.
Howenstein, okay. Carson,
Yes.
and John Ward.
Yes.
Okay. All right. We will move to executive session. We'll need to clear the room. 15 minutes should
Yeah.
be should
Recording
be
stopped.
ample time. Okay, we are back from executive session. Next item on the agenda is Dr. David Singer's appeal to the APCHA Board, appealing the hearing officer's written decision regarding Dr. David Singer's lease termination. So we've got Tom, who's going to be representing APCHA staff. Who's going to be representing Mr. Singer?
This is Christopher Bryan on behalf of Dr. Singer.
Chris, come on up.
Thank you. Tony, do you want to come up here too? I've got Tony Mendez with me as well.
Okay.
I'm here with Alpine Legal Services.
And I am a local attorney with the law firm of Garfield and Hecht, although I'm appearing here pro bono at the request of Alpine Legal Services on behalf of Dr. Singer.
Okay. So typically, the way that that these appeals work is we generally try and allot about 30 minutes for each side to kind of present, and if you want to reserve some of that time for follow-up after I think, Tom, are you going to go first?
No, the appellant.
The appellant's going to go first. Okay, so if you guys want to go, you'll have half an hour. If you want to reserve some of that time to respond after Mr. Smith, feel free to save that time. I'll keep track of it here for you.
Okay, I'll try to keep track of it too, so that we're on the same page. I will reserve about 5 minutes of rebuttal.
Okay.
Okay, my name's Chris Bryan, as I told you. I'm here today on behalf of Dr. David Singer. He's 87 years old. He's lived in Aspen since 1983. He's resided in his APCHA unit for more than 13 years. And I want this board to be very clear-eyed about what is being asked of you today. If you do not grant this appeal, Dr. Singer will be evicted. He'll be homeless. He has nowhere to go. His life will be in complete shambles. He has been in a state of depression since this process began, and many close to Dr. Singer fear the worst if you decide to allow him to be evicted at staff's recommendation. He has been prescribed antidepressants as a result of this process. He's also suffering from long COVID. There are several procedural and legal bases for you to grant our appeal, and you should. You should set aside the hearing officer's ruling. But we'll get to the legal aspects here, but first I want to get big picture before we get real granular. I want this board to remember that we're talking about a human being here. So many of the decisions that come before you are more abstract in the sense that we talk about building new affordable housing units, we talk about the lumber yard in concept, we talk about new taxes for the county to have more affordable housing. Generally, right now we're talking about a single human being whose life, and I'm not being hyperbolic, hangs in the balance based on what you 5 people do today. I ask you to have a heart and to exercise your compassion. That's part of what you're asked to do as representatives of this community, both elected officials and appointed. We acknowledge that Dr. Singer's relationship with APCHA is strained. It's not ideal. And he's not proud of everything that has happened in the last decade or so, and especially in his weakened mental state. But you should know this. Since this process began, there have been zero incidents concerning Dr. Singer. Now he's getting the care that he needs as an 87-year-old, and future incidents can and will be avoided. We ask you to do the right thing. Let Dr. Singer remain in his home. Please don't ruin his life. I urge each of you to recognize that Dr. Singer is now getting the care and medication he needs. Now let's talk about the legal aspects, because you're going to need to understand this. I hope Ms. Johnson has explained to you the standard of review in executive session, but very briefly let me go over it. Your standard of review is provided by APCHA regulations that govern this body when it sits in a quasi-judicial proceeding such as this. It states that the appeal shall be based solely on the record before the hearing officer. That's section 6, parens 5, F2A. As APCHA has pointed out in the briefing, you're not bound by the hearing officer's decision. You may affirm, reverse, modify. You can remand. You have a lot of discretion here. So you shouldn't feel like your hands are tied in any way. The question is whether the hearing officer was correct in determining that APCHA has good cause to terminate Dr. Singer's tenancy. Under federal law, that's Code of Federal Regulations, section 966.413, Romanet 4, for those of you keeping track. APCHA may only terminate the lease, despite the fact that it's a month-to-month lease, for good cause, not at will, for good cause. That's federal law. that binds you. The hearing officer's ruling was untimely. This is perhaps the easiest way for you to grant the appeal. We don't need to argue about any of Dr. Singer's conduct. We don't need to get into the legal nuances. If you just read APCHA's own regulations and apply them as written. APCHA's 2023 regulations state in section 6(5)(b)(2)(f) that the hearing officer shall make its decision in writing within 30 days of the conclusion of the hearing. There is no dispute here. The hearing is concluded on November 2nd, 2022. 30 days from that is December 2, 2022. Guess when your hearing officer got around to issuing a written ruling? Anyone? No? 135 days later. 135 days later. March 17th, 2023. So the ruling was untimely and violated your own regulations. There's no wiggle room in APCHA's rule here. It uses the word shall, which courts everywhere shows a mandatory requirement. Colorado courts in particular have held that agencies must scrupulously follow the regulations and procedures that they promulgate or their actions will be stricken. That's Rags over the Arkansas River, Inc. v. Parks, 360 P. 3rd, 186, Colorado Appeals Court, 2015. APCHA says that Brock v. Pierce County, which is a 1986 Supreme Court case, stands for the proposition that the hearing officer can ignore the 30-day requirement with impunity, that it's optional. Doesn't have to comply with the shall. In other words, APCHA is arguing that the requirement in its own regulations is meaningless. Well, why is it there, I would ask, but let's move on. The interpretation that APCHA is advancing to you is plainly wrong. The Brock case involved an interpretation of a federal statute, the Comprehensive Employment and Training Act. Under that statute, the federal government provided funds to local governments to provide job training and economically disadvantaged people. Anyone is allowed to submit a complaint to the U.S. Secretary of Labor alleging misuse of funds under that statute. The statute itself says that the Secretary of Labor needs to determine the truth of the complaint within 120 days of receiving the complaint. 1986, the United States Supreme Court was interpreting a federal statute passed by Congress. That is very different than an agency like APCHA adopting its own regulations. This wasn't imposed legislatively on you. You yourselves in your regulations said there's a 30-day requirement for your hearing officer to issue a ruling. That's different than the General Assembly of Colorado imposing that on you legislatively. That's different than the U.S. Congress imposing a federal statute on you legislatively. This board adopted these regulations. That's your own rule. So that's a key distinction. The U.S. Supreme Court's decision in Brock, which is the case that APCHA is relying on, turned on the fact that important public rights were at stake and not allowing the government to recover fraudulently delayed funds because of a violation of the 120-day requirement would prejudice the rights of the taxpaying public. Here, there are no public rights at stake. This is a private matter between APCHA and Dr. Singer pursuant to a lease for a residence. The main basis the Brock case turned on does not exist here. It's inapplicable, and you should not hang your hat on it like APCHA wants you to. Therefore, APCHA's reliance on that court ruling is misplaced. Moreover, the 120-day limit came from Congress, not the Department of Labor's own agency regulations. That's why it's different. APCHA's position is contrary to the settled law that an agency must scrupulously follow, it's in quotes, its own regulations. These are your regulations. If you don't like the 30-day requirement for your hearing officer to turn around a ruling, get rid of them. But you can't have them in writing and then not enforce them. That's not the way this works, especially under Colorado law. After 30 days passed, the hearing officer lost jurisdiction to issue a ruling. Nevertheless, 135 days later, he got one out. He exceeded his jurisdiction when he did that, and as Ms. Johnson has hopefully explained to you or will, that is grounds for you to reverse the ruling. Otherwise, a court's going to have to do it. I hope it doesn't come to that. For this reason alone, you should set aside the hearing officer's ruling. We don't want this to end up in the courts. And we don't want APCHA to have to spend its finite dollars to pay a lawyer to have to litigate this matter in state court. We want APCHA to do the right thing and not make Dr. Singer homeless. The 30-day rule is a requirement that you yourselves imposed upon your hearing officer. You cannot ignore it. He should not have ignored it. The hearing officer didn't follow it. That's reason enough to set the decision aside. But wait, there's more. APCHA has waived Dr. Singer's alleged lease violations, or they are barred by the statute of limitations. APCHA entered into its current lease with Dr. Singer on August 1st, 2021. That's on page 423 of your packet. Anything that occurred before that date has been waived by APCHA because they occurred under an old and no longer enforceable lease. This is basic contract law under Colorado law. You can't say that Dr. Singer breached his current contract with APCHA, the August 1, 2021 lease, by referencing things that happened before that lease was executed. The federal courts in Colorado have said as much. For example, in Branta LLC versus Newfield Products Company, 310 F Sup 3rd, 1166, the United States District Court for the District of Colorado held that there can be no breach of contract for alleged damages occurring before the actual current contract was even executed. APCHA says that if it can't backtrack and look at those pre-lease or pre-August 2021 incidents, it won't be able to terminate the lease. APCHA could have conceivably terminated the previous lease under those incidents before entering into the new one, but it didn't. That's not what happened here. When APCHA entered into the new lease with Dr. Singer in August 2021, it waived all prior alleged lease violations. You can't have a lease that expires and then you get a new lease that supersedes it, and then you want to enforce the new lease and evict under it by going back in time to violations to the prior lease. That's common sense, but I hope you also understand the legal significance of it. Moreover, there's a statute of limitations here. There's 3 years under Colorado law. That's in Colorado Revised Statute Section 1380-101. APCHA began this process when it sent the notice of termination on June 6, 2022. That's on page 421 of your packets. So anything that occurred before June 6, 2019, it's 3 years before, is not only waived by operation of the new lease, as previously explained, but it's also barred by the Colorado statute of limitations. So let's look at the alleged lease violations. This is what APCHA is hanging its hat on. These are on page 450 of your packet. Violation numbers 1 through 23 all occurred before August 1, 2021. Those are completely irrelevant as a matter of law to what we're talking about here today, since they've been waived by operation of the August 2021 lease. What did the hearing officer rely on in his ruling? Well, we've got APCHA exhibits H, M, Q, U, T, V, and Y. The hearing officer references these on page 8 of his ruling. That's page 36 of your packet. In exhibit H, a woman named Sandra references an encounter on January 30th, 2019. That's page 465 of your packet. That is barred by the statute of limitations and was waived. Exhibit M occurred on November 19th, 2019. That's page 472 of your packet. That was waived by entering into the new lease in August of 2021. Exhibit Q concerns an incident on April 9th, 2020. That's page 476 of your packet. It was waived by entering into a new lease in August of 2021. Exhibit U concerns an April 27th, 2020 incident. That's page 484 of your packet. It occurred after the new lease was executed. Carson, what's my time check?
I got 10:45.
Excellent. Exhibit U concerns an April 27th, 2020 incident. That is page 484 of your packet. It occurred after the new lease was executed. It was waived. Exhibit T concerns an incident on April 22, 2020. That's page 482 of your packet. Again, this incident was waived by entering into a new lease in 2021. Exhibit V concerns an incident on April 28th, 2020. That's page 485 of your packet. Again, this was waived by entering into a new lease. Exhibit Y concerns the July 30th, 2020 incident. That's on page 487 of your packet. That too was waived because it occurred before the new lease was entered. Legally, the hearing officer should not have relied on those incidents as a basis for a finding of good cause to terminate the lease. And you can't rely on it. It would be an abuse of your discretion. You'd be exceeding your jurisdiction if you did that. The hearing officer did it anyway, ignoring Dr. Singer's objections. Notably, all of these things happened at the beginning of the COVID-19 pandemic. Like many of us, Dr. Singer was struggling mentally and emotionally. He regrets his actions and behavior during that time. Since that time, he's been receiving help from Pitkin County Health and Human Services. He's been diagnosed with anxiety and depression, and he is on medication that is helping him immensely. He's here in the room today. He has committed himself to getting the care he needs to be better. He has a caretaker who helps him with daily activities. I ask you to do the right thing here, to accept that people do things they regret at their lowest points, but that they're capable of change. And especially since all of those incidents that the hearing officer was relying on are legally not enforceable bases for good cause. Now, I'm going to get back to this a little later, but I've received an outpouring of letters from people close to Dr. Singer over the last 2 weeks, and one I want to mention now is from Emily.
Objection, this is going beyond the record. The hearing record is closed.
Your objection is noted. Thank you. One I want to mention now
So
was from Emily.
We do have to stick to the items that are in the record. Okay.
I understand. I'm allowed to make my presentation, and you can consider what you want.
No, that's not true. I would think you
Yes.
should consult with
Yeah.
Kate to determine if information, he's testifying.
Right.
First of all, those people aren't here. Now you got Chris Bryan, attorney for Dr. Singer, testifying to facts, attempting to testify to facts that are not in the record.
How do you know what I'm going to say?
You just said what you were gonna say.
I'm not testifying
You
about
said
facts.
you were gonna.
Order.
Will you stop yelling at me, please?
I think the board certainly is directed pursuant to APCHA regulations to only consider the record before the hearing officer. Mr. Bryan has indicated he intends to present evidence that was not before the hearing officer in this case. Certainly, I think that the board can strike that evidence from this record if they feel it is outside of the directive here, which is to only consider the hearing officer's record.
Thank you, Ms. Johnson. I will make my record, and the board can do with it as it pleases. Emily Langford, who's a case manager from the Pitkin County Department of Health and Human Services, has written to advocate that Dr. Singer, a longtime Aspen local senior veteran and retired ophthalmologist who's 87 years old, has been extremely stressful for Dr. Singer, these proceedings, and they have allowed him to reflect and continue to get connected to the resources and supports to age in the community he loves, and their department asks you to reconsider pursuing his pending eviction status. Now, even if you consider the incidents that were referenced above, which you shouldn't because it's legally improper, I would ask you to find forgiveness in your hearts for this 87-year-old man. He regrets these incidents and is deeply apologetic. Now, the hearing officer was very concerned with APCHA Exhibit HH. You can read his discussion of that email, among other places, on page 33 of your packet. The hearing officer did not mention that in his ruling, but APCHA served Dr. Singer with a notice to quit on April 7th, 2022. That's page 406 of your packet. He was scared, lonely, and suffering mentally and emotionally. He was reeling from the effects of long COVID and dealing with untreated, at the time, anxiety and depression. That's the context of these incidents, which the hearing officer completely ignored. Mr. Singer regrets his actions, but since then he's gotten help. And the harassment charges that that were brought against Dr. Singer were dismissed, and those isolated incidents which occurred during a time of great stress are not indicative of his character. Now, you should not ruin Dr. Singer's life over an incident that happened on April 7th and April 8th, 2022, but that's really all APCHA can ask you to do because all the other incidents have been waived. Now, the dog off-leash incidents are barred by the statute of limitations or were waived. If you look at page 450 of your packet, you'll see that there's only one dog off-leash incident that occurred after August 1, 2021, just one. The hearing officer spent a lot of time in his ruling discussing incidents as far back as 2019, but those were inappropriate for the hearing officer to consider. Exhibit GG, pages 504 through 505, contains an instance from April 7th, 2022. Again, this email is not so much about the dog as it is about Dr. Singer's reaction when he was told to keep his dog on a leash. Again, Dr. Singer was in panic mode. He received a notice to quit that day. The dog in this instance did not do any harm. On August 10th, 2022, there was an incident with Dr. Singer's dog. That's Exhibit 00 on page 518 of your packet. He was having trouble with his dog. Walking the dog on a leash with a cane was difficult, but he learned his lesson, and now he doesn't walk his dog without a leash. I ask you not to ruin Dr. Singer's life and make him homeless over an isolated incident about a leash with a dog. At 87 years old, the dog keeps Dr. Singer active. He loves his dog. He's keeping his dog on a leash. It does not warrant making him homeless. APCHA's allegation that Dr. Singer failed to upkeep his unit was also waived. On page 11 of the hearing officer's ruling and page 39 of your packet, the hearing officer states that Dr. Singer failed to maintain his unit. He relied on Exhibit BB to come to that conclusion, which begins on page 490 of your packet. If you look at page 491, you'll notice that the pictures were taken on July 20th, 2021. Well, what's that? That's 11 days before the new lease. That too was waived. I also note that the pictures were taken by an APCHA agent coming into Dr. Singer's homes to make repairs and surreptitiously taking those pictures. There was no invitation to begin collecting evidence or taking pictures, and there was no notice for that purpose of collection of evidence or to do an inspection for that purpose. That violated Dr. Singer's privacy rights, both under federal and state law. That Dr. Singer's unit was messy in July of 2021 is not a reason to make him homeless now, legally or factually. Not only was this alleged violation waived because it happened before August 1, 2021, but Dr. Singer's 87 years old. Now he has help from caretakers to maintain his unit. And we all know that someone in a mental health crisis often fails to take care of themselves and their home. That's what happened here. Now that Dr. Singer has the care and medication he needs, he's able to take care of his unit. There have been 0 incidents since this proceeding started. That's not a reason to evict Dr. Singer. Failure to timely pay rent is not grounds to evict Dr. Singer. In fact, it is an illegal basis for you to do so under Colorado law. In fact, some of you might be familiar with A new law that went into effect that the democratically led General Assembly of Colorado passed during COVID and that our Governor Polis enacted as part of the landlord-tenant legal reforms. But the hearing officer didn't take note of that statute. Instead, he noted that Dr. Singer failed to timely pay rent in the past. That's page 12 of the ruling, page 40 of your packet. Again, if you look at page 450 of your packet, you'll notice that no failure to pay rent occurred after August 1, 2021. So that's a pre-lease violation that's irrelevant and has been waived. But regardless, under Colorado law now, that Governor Polis signed, a tenant may pay rent owed to a landlord at any time prior to a judgment for possession issued by a district court judge. So that's not a basis. Plus, if that's not enough for you, you got federal law. Failure to pay rent is only good cause for terminating a lease when the failure is serious and repeated. Dr. Singer is current on rent. There are no serious or repeated violations for failure to pay rent. That's not a grounds to terminate his lease. The hearing officer violated Dr. Singer's due process rights by refusing to continue the hearing. On the first day of the hearing, Dr. Singer's counsel from Alpine Legal Services, Mr. Mendez, who's sitting to my right, requested a continuance because Dr. Singer had recently been hospitalized and was unable to attend the hearing. You see that on page 53 of your packet. The hearing officer denied the request. Why? Because he said that the lawyer should have worked the issue out. That's on page 55 of your packet. But due process fundamentally is a constitutional right to be heard. That's Jefferson v. Colorado Department of Social Services, 847 P2nd 408, Colorado Appeals Court, 1993. Dr. Singer could not be heard because he was too sick to appear on his own behalf. And in Fortner v. Kusar, 992 P2nd 697, Colorado Appeals Court, 1999, a due process violation occurs when a continuance was denied when a party's lawyer, not even the party, but the party's lawyer was too sick to attend the hearing. Similar facts appeared here. The hearing officer had vast discretion to continue the hearing, and he abused that discretion when he refused to do so on good grounds that Dr. Singer was in the hospital. The hearing officer's ruling is void because he engaged in unlawful ex parte communications. The hearing officer and APCHA's Deputy Director of Housing, Ms. Christensen, engaged in ex parte communications regarding the hearings. That's on page 588 of your packet. This directly conflicts with the hearing officer's obligation to remain scrupulously impartial, as we explained in our brief at 586 of your packet. That was an ex parte communication where the hearing officer was consulting with the APCHA staff about the merits of the case. This is a patent due process violation, which is grounds enough for you to grant my appeal. Peretti v. Hyman, 1979, from the District of Massachusetts, that holds that an ex parte contact between a public housing authority, which APCHA is, and a hearing officer that are ex parte. You know what ex parte means? That means the other side doesn't get to be included in those. Are fundamentally inconsistent with the hearing officer's obligation to be scrupulously impartial. That's from a federal court about a housing authority and their hearing officer. That's directly on point. The hearing officer is the former mayor of Aspen. He's a former Pitkin County BOCC member. He's a weekly newspaper columnist who writes frequently about housing issues. And he wrote many of the regulations that he's now trying to enforce. There was a bias here, and the ex parte communications violated Dr. Singer's due process rights. Finally, the hearing officer failed to consider all the relevant circumstances. Now, you have to look at federal code on this. The Code of Federal Regulations, section 982-310H1, the hearing officer must consider all circumstances before terminating the lease. He omitted several circumstances in his ruling, such as the testimony of an Aspen police officer, Amanda Severin, concluding that Dr. Singer is not dangerous. That's 294 on your packet. He also did not consider the instances where Dr. Singer showed and expressed personal responsibility and remorse and the effect the eviction would have on him and his community. The hearing officer did not consider Dr. Singer's advanced age or his health problems or what he was dealing with in April 2022. That was a violation of federal law. Do you know why? Because there are numerous circumstances in which the hearing officer did not consider circumstances relating to the individual at issue who was at risk and vulnerable and on public assistance. Federal law requires APCHA to describe its policies for selecting a hearing officer in its leases. That's 24 Code of Federal Regulations, section 966.53E. It's also at 24 Code of Federal Regulations at section 966.4N2. It didn't happen here. This is another easy reason that a district court judge is going to take one look at this case and toss the hearing officer's ruling aside. But we can avoid that if you grant the appeal today. The August 2021 lease does not comply with federal law. It does not include a description of APCHA's policies for selecting a hearing officer that the Code of Federal Regulations at 966.4N1 requires. The provision does not exist in your lease. Even worse, it is a month-to-month lease, which is not allowed under federal law. CFR, section 966.4A2I. APCHA says this is no big deal because it only applies to his lease term, not the question of whether he's entitled to a lease at all. But like the 30-day requirement, this is APCHA saying the rules that apply to other people don't apply to it. Do you see how that looks? I heard in board comments you're concerned about your reputation. It doesn't look good when this board has rules and doesn't enforce them. When this rule says the rules don't apply to it. When this board's own regulations are not applied to its own hearing officer. When this board does not comply with state and federal law. That's how you lose faith in a community. That's how your reputation gets tarnished. APCHA's position that the lease includes a description for selecting the hearing officer is plainly wrong. Look at page 443 of your packet. Finally, there's a new law that went into effect 15 days ago. Colorado passed House Bill 23-1120 on June 6th. That requires mandatory mediation before anyone on public assistance can be evicted. Dr. Singer's an 87-year-old disabled veteran. There have been a lot of support for him in the community. There's been no incidents. These are ticky-tack bases to try to evict a man who has nowhere else to go from our community. You are the housing authority, not the eviction authority. Last night I went to an Aspen Institute event for Aspen Words and listened to Margaret Atwood speak. I don't know if you know who she is, but she wrote The Handmaid's Tale and about 49 other books. And she said in her question and answer section of her presentation that her biggest fear is how our society treats the elderly. I want you to think about that. How is this board, how is our community treating Dr. Singer? I know each of you, individually, to be good and well-intentioned public servants. But for all the talk that we have on elected boards and here in the APCHA room about community and Aspen values, that will all be hot air if you make a ruling today that results in Dr. Singer being homeless. So it's time to do something tangible for someone where this board can actually make a difference in someone's life for the better. I reserve the balance of my time.
Okay, thank you. Tom, you go ahead. I guess first, are there any clarifications or questions as to where things are located in the record?
I have one question, Chris. You mentioned that Dr. Singer had been in the hospital. Could you cite that in the...
Could I cite what for you?
That Dr. Singer was in the hospital on the day of the hearing?
Yes. You want me to point you to the packet on that?
Yeah, because I thought I recalled reading that he had been in the hospital, was not in the hospital on the day of the hearing.
Tony, do you have an immediate recollection of that? I'm looking for it in the record, but you were there that day.
I was there. He had been in the hospital that day. I was told, I tried speaking with Dr. Singer that morning, going to the hearing on my way up to Aspen, mainly to make a record because the purpose of creating a record was for appeal, and we had objected to Mick Ireland being the hearing officer. So before the hearing was even had, we had an objection to Mick Ireland being the hearing officer based on his bias and as you've heard previously, I'm sure not just on this situation, but in previous situations.
But that wasn't the point of my question.
I understand. And
it was just on the where Dr. Singer was on the first hearing.
Right. So I was on my way up to the hearing when I gave Dr. Singer a call to let him know, and I even showed up at his home to make sure to let him know, and so that he could come to the hearing with me. And he was not well enough to leave his home. He gave me a medical record or a report. I gave it to Mick Ireland.
Please testify.
I think the question is just, is there a reference to the record where...
Page 53, bottom, Mr. Mendez, transcript from the hearing. Thank you. So I'm handing you, and I'm sorry, these are Dr. Singer's notes. I got them this morning. These are medical reports. He was at the hospital. He didn't get out until about 5 p.m., which is why I was not able to make the request earlier. I didn't know about them until then. The medical report is pretty sparse, but when I spoke to him on my time off, he let me know his doctor had told him he needs to rest and he should not be stressed. So we were asking for a reasonable accommodation, a continuance of this hearing so that he may visit his primary care physician to determine the extent of his stress and health. It goes on to page 54.
Thank you.
You're welcome.
Allison?
Hi, Chris. You've mentioned several times that the Dr. Singer is now getting the care and medication that he needs, and there's been 0 incidents. I believe since this happened, which I think means we can't consider it, that's not in the portion of the hearing that we're able to consider.
Well, sure it is. Otherwise, you would have them before you. The absence of them shows that they haven't happened. Right?
There's nothing in the record that we're looking at that shows that he is now on the care and medication that he needs.
I don't think that you. Okay, there's 2 issues there. There's the 0 incidents. The fact of 0 incidents, you can take notice of, because if there had been more than 0 incidents, they'd be in the record, right? So the absence of them means there have been none.
I think you mean since this record was compiled?
Since this proceeding began.
Okay.
Right. That he's under care of medication, I mean, that's obvious, right? That is for the that explains the changes that we've seen.
There's no reference to it in the packet.
Well, I would love to be able to tell you from the Pitkin County Health and Human Services letter that I received that he's under health and care, but APCHA's lawyer doesn't want that in the record for reasons that I find very suspect.
Thanks, Chris.
You're welcome.
Okay. Tom, would you like to go ahead?
Well, the reasons that Mr. Bryant considers so terribly suspect that I don't want the record expanded is, and at the same time he talks about enforcing the rules, it's pretty obvious what's going on, okay? He has testified about Dr. Singer's current situation, his alleged current condition, the potential for homelessness. There's nothing in the record on any of this, okay? And the rules are very clear, and they've even admitted what the rules are, which is that your decision should be based on the record. There's 0 information about Dr. Singer's current condition. There's nothing in the record to state that homelessness is the inevitable outcome of your decision. And I wonder where we'd be if every time we had an eviction case or a lease termination or requirement to sell property, do we just have to sort of buy into these assertions that somebody's going to be homeless? I'm glad that Mr. Bryan brought up the issue of compassion and treating Dr. Singer as a human being. Has he done that? On April 7th, 2022, the Housing Authority pressed charges and Dr. Singer was arrested for harassment. There's a video that's in the record that shows exactly what he did. That was the basis for that arrest. He was banging on the APCHA windows. He was shouting and screaming at staff. He was extremely aggressive and hostile. That incident was preceded on that day by a death threat by him to an APCHA employee in connection with his dog being out of control. And Dr. Singer objecting to being told that his dog was out of control and that he needed to do something about it. Later that day, now all this is in the record, exhibits 3.GG.HH.NN. Later that day, he was verbally abusive of Tim Horn, the property manager out of the project, at length. Cursing, shouting, screaming, abusive behavior, conduct that no person should have to put up with. Your employees included. On April 8th, the abuse continued. He continued to verbally abuse Tim Horn, cursing, shouting, taunting him. Tim Horn testified that he thought he was trying to be drawn into a physical conflict by Dr. Singer. On July 28th, 2022, we had another incident of harassment of a tenant in connection, once again, with a dog. And Dr. Singer threatening violence to that other tenant. On August 10th, Exhibit 3.00, his dog attacked and bit a person. The inevitable outcome of a long history of Dr. Singer not controlling his dog scaring people, barking at people, and scaring them. And guess what happened? That's why we have these rules. That's why all leases have these rules. Your dogs have to be under control, and his wasn't. 0 incidents. This is an interesting thing. We're talking here about the most crucial incidents of lease breaking, criminal activity, violent conduct occurred last year. And Mr. Bryan conveniently didn't say one word about those incidents. Not a peep. Of course, he's got a host of legal arguments to make because the crucial facts aren't in dispute. At the hearing, Dr. Singer testified that he didn't dispute the facts, even though later on he said that all APCHA employees were liars. Does he have any credibility in that hearing record? The hearing officer found, quote, while all of the alleged violations must be taken seriously, harassment and violent conduct are simply not acceptable behaviors by APCHA tenants or within the community at large. That says it all. That's what this case is about. You're being asked to give Dr. Singer a huge break, one in which, in circumstances in which he has harassed your employees, made them scared. He told Tim Horn on a telephone message, I have a gun and I know how to use it. I mean, what has to be tolerated here? What's the limit? Where was Dr. Singer's compassion when he engaged in this conduct? Mr. Bryan misquoted the applicable federal regulation about considering all of the circumstances. He substituted, in his infinite wisdom, the word must for the word may. The owner may consider all the circumstances relevant to a particular eviction case. And the hearing officer, in a well-reasoned decision, considered the circumstances that he thought were relevant, and he doesn't have to consider all of them. One objection is that the record, or the assertion is that Dr. Singer has shown personal responsibility. That's not true. He didn't take any responsibility for what he had done. At the hearing, he said they were liars, even after saying it all happened. The effect of the owner's actions on the integrity of the program. Well, that's a pretty big circumstance here, isn't it? What's the message? What's the message if violent conduct, death threats, threats related to guns, cursing and swearing, screaming at APCHA employees, banging on the windows to the point where APCHA employees thought that the windows were going to break? What's the message to the program if that conduct can be tolerated? As far as the decision being untimely is concerned, Mr. Bryan has an elaborate argument about why the U.S. Supreme Court's decision is not good law. But the fact is that state courts follow federal law all the time. The Brock case that we cited is precedent for decisions in a number of jurisdictions for the principle that if there's a deadline imposed on the government to make a decision, but it doesn't identify any consequences for that decision, then the decision can be made later. There's no conflict in the law about that. Now, what Mr. Bryan is relying on is case law that says where a government agency adopts rules, it has to follow its own rules. And that's true. But that involves substantive requirements. It doesn't involve this. It doesn't involve the timeliness of a decision. So what are we supposed to think is the outcome of agreeing with Mr. Bryan? We just start all over again, have another hearing, and then tell the hearing officer, well, now this time, make sure you tie it in 30 days. What comes out different? The fact is, there's no prejudice in the delay. Mr. Singer's still there, and it hasn't interfered with their ability to present a defense. And there are public rights at stake here. Dismissing his case on those grounds would be highly inequitable. It would amount to endorsing the conduct that resulted in the notice of lease termination. Which brings up another point about state law. Okay, this case came about because APCHA allowed Dr. Singer's lease to expire and then told him he had to leave. You can do that under Colorado law. You don't have to renew somebody's lease. They have no property interest in the renewal of a lease. And you don't have to show good cause. So that was how this started. When the defense was raised that because it was a low-income housing tax credit program, we had to follow regulations, we said, okay, we agree. We'll dismiss this case and we'll proceed to a hearing under the federal rules. That's what this hearing is about and what this appeal is about. It's not about state law. It's not about anything in state law. Because this is all about complying with federal law, both in terms of procedure and substance. So all those arguments are without merit. The selection of the hearing officer, it's about providing notice about how a hearing officer will be selected. It doesn't give the aggrieved tenant a right to have anything to say about it. It's about notice, and that's in your rules. It says how a hearing officer is appointed, and a hearing officer doesn't have to be appointed on a case-by-case basis. The month-to-month lease issue, well, as I said in my hearing brief, it has nothing to do with what we're talking about here. Dr. Singer is on the premises. The fact that he's been on a month-to-month lease since enforcement began has not yet resulted in his being terminated. So the month-to-month lease issue has absolutely nothing to do with what we're here talking about. There is no mandatory mediation applicable to this case under the federal rules. Mediation is an option, and APCHA, because of the severity of the violations that have occurred here, APCHA staff has had no interest in mediating with Dr. Singer. And frankly, what's the compromise? He either stays or he goes. And should APCHA let him stay with this kind of a record of conduct? You have several employees out there who are scared to death of Dr. Singer, who lives across the street. Is that a tolerable situation? And what if Dr. Singer finally goes postal and we have let him stay there? What then?
Objection, that's outside the record.
It's not a fact. It's true that if we were attempting to evict Dr. Singer based on individual lease violations that occurred before the lease renewal, that couldn't happen. That's not what this case is about. This case is about a pattern of conduct, and a pattern of conduct is a legitimate basis for terminating a lease under the federal rules. That provision is only meaningful if you can go back to the pattern beginning without any need to confine it to the most immediate period of time. So that's the reason that we think that all those violations, particularly the most severe violations, are relevant to this appeal. Regarding the denial of a request for a continuance, Mr. Bryan overlooks the fact that on the Friday before that first day of hearing, Dr. Singer had already said he wasn't coming. In fact, he and his lawyer both said they weren't going to show up. They didn't like the way it was going.
Objection outside of the record.
It's in the record.
Where?
It's a communication with the hearing officer.
I'm in the
That-
packet. What page in the packet?
It's attached to my brief.
Okay, what page in the packet?
It's not, I don't know what packet number it has. It's Exhibit B to my hearing brief, and it's the exchange with, among Mr. Mendez, myself, and the hearing officer.
Okay, but that wasn't in the hearing.
What?
You attached it to your brief. That wasn't part of
Attach
the
it to
record
the brief,
below.
and
That's part of this
and it
packet,
was
but that's
dis-
not part of the record below.
it was considered by the hearing officer
Where was that in the transcript then, that he considers it?
when this, are we going to question and answer here?
I just want to know where it's in the
I
record.
think I don't have to answer
I
that
certainly
question. He
think
can
if
make
the-
his argument.
The board has questions as to whether something's in the record, they can ask for that clarification.
I hope it does.
This point was made on the record in any event, that he was not going to show up. And then conveniently, on the Monday, Mr. Mendez shows up, contrary to his prior representation, without Dr. Singer. Dr. Singer was not admitted to the hospital. There is no, talk about what's not in the record, there's no medical report in the record. Okay? He went to the ER and they told him, get some rest. There's no record of any condition that prevented him from showing up at the hearing. No doctor showed up. In fact, we didn't get the name of a doctor on anything. So on that day, following normal procedure, Dr. Singer's case would have been presented first. Mr. Mendez asked us to proceed first, and we agreed. So on that day, neither Dr. Singer nor any of his witnesses were required to testify. They showed up on the second day and testified. All of his witnesses testified. He was on notice of the hearings, obviously. On the first day, there was no presentation of evidence on his behalf. His attorney was there to cross-examine all the witnesses, the APCHA witnesses, which he did. On the second day of the hearing, he presented his entire case. There was no prejudice whatsoever in the hearing officer's denial of the motion for a continuance, and as the cases hold, that's a matter of the hearing officer's, matter within the hearing officer's discretion. The briefs are lengthy, they're complete, there's a substantial factual record in front of you in the exhibits that APCHA has presented. You have the transcripts of the hearings. I'm not going to go into every legal argument or every factual issue that is present here. Dr. Singer's plea for compassion, that's all he's got. But APCHA is not a social services agency, for better or for worse. Dr. Singer belongs somewhere else. APCHA is not responsible for finding him another place. If there's all this community support for Dr. Singer, perhaps there should be some support for him to find another place to live and to preclude him from being homeless. But APCHA has a responsibility to the Truscott tenants, to its own employees to make them feel safe and secure. And tolerating the kinds of abuse that Dr. Singer has subjected people to just last year is not acceptable. So APCHA staff urges you to affirm the hearing officer's decision.
Okay, thank you, Tom. Kelly?
I actually think I have more questions for Kate, but maybe if we go into exec, I'll ask those. But I'm wondering, Tom, why did APCHA sign a new lease in August 2021?
Because it's
And I would
well,
just,
that's not
I
really
would just
on the
advise
record.
council that certainly you can ask if there was any evidence in the record about that particular topic.
Yeah.
But to the extent it was not considered by the hearing officer or not referenced in the hearing officer's, not made available to him, I would advise that the board not inquire about evidence that was not presented during the hearing officer.
It's not in the record, and I'm not the witness I'm not a witness anyway.
The
I
lease,
have a different
the lease is in here.
Is the lease in the record?
Yes.
Because I tried to print out what I thought was pertinent, and I didn't get the lease, but
The lease is in the record.
my question is there a clause in the lease on quiet enjoyment, behavior of other tenants, or other neighbors, whatever else?
We have cited numerous places, for example, in the exhibit, APCHA Exhibit 3, I'm sorry, but I don't know what
Exhibit
page
3.
it is in your packet. It's actually Exhibit 3, and it's a list of exhibits from A to,
I think it's on page 423, if you want to be specific. I think that's the August 21 lease.
and the specific question, I'm sorry, was about,
With regards to quiet enjoyment,
oh, that's in number 1.
interference of.
Well, okay, in the exhibits, we have, or I should say, in the notice of lease termination, reference is made to the lease provisions violated. So, and Exhibit 2 identifies the date of each. It says statement of grounds for lease termination. It has a date on each of the 27 violations, a description of the violation, and a reference to the provision of the lease that's violated. Okay. On the terms of the lease itself, the lease is Exhibit 1 in our exhibits. And that includes applicable provisions which we've cited, as I just mentioned, and
This may not be part of the record either, but in the lease, it says no tenant shall be permitted to house any dogs or cat unless it's a trained service animal or emotional support animal as
we
determined by
cited,
APCHA.
on the dog violations, we referred in that Exhibit 2 to the applicable requirements of the lease, which I believe are paragraph 7.0 of the lease as cited.
Kelly?
On page 42, where the order is detailed, though not, where the beginning of the order is detailed, though not signed,
I'm sorry, the
order that, from the hearing officer?
hearing officer's findings of fact, conclusions of law, and
And
ruling.
then the order. Thank you. Were those provisions of the order followed through with? Does the record indicate that?
I'm sorry, if that's a
I'm-
question for me, I'm not sure what.
So I'm reading, for example, APCHA is ordered to extend the lease for 3 months with a possible 3-month extension upon review of his conduct at a further hearing 3 months from the date of this
So
ruling.
again, I think you're getting outside of sort of the scope of your review here. I agree that that was part of the order, but I think at this point, the question remains as to the review of.
So the order never took effect because an appeal occurred.
Well, correct. That's my understanding, is that it's pending, the outcome of this procedure, and your job here is to review the conclusions and finding of law and to determine if, as Mr. Bryan pointed out, there was any wrongdoing or an abuse of discretion or excess or exceeded the officer's jurisdiction. So I don't know that that's relevant to the issue before you.
Okay, well, I would say what I'm reading here are there conditions to remaining in a unit or a termination taking effect immediately.
You do have the power
So-
to remand or then to modify this decision, including, I think, those terms.
Right, okay,
So I do think that's within your power.
okay,
I don't disagree with that.
thank you. Okay, and I guess, again, I don't know if this is for you.
You can ask it, and if it needs to be an executive
Sure.
session, we can make that
related
determination.
to issues of due process, does due process become restored through participation in the second hearing date?
I certainly think that the participation in the second day is relevant to the question before you. But I don't think that there's a definitive yes or no answer to that question. I think you're looking at the totality of the circumstances in this case as to whether or not there was notice given of the hearing and an ability to, one, have a hearing, a hearing option was made available, and then the ability to participate in that hearing. Now, whether or not there was abuse of discretion as to whether the hearing officer denied the continuance, that's a question before you, and I can't answer that question, but I can say that I think that that's relevant to your issue.
Okay,
They
thank
can
you.
speak if you want a position on what the position is of each of the parties. I think that's an appropriate question.
I did have a clarification on that topic. I think, Mr. Mendez, you had said that Mr. Singer was in the hospital on the day of the hearing? Or did I mishear that?
No, he was at home.
He was at home, okay, all right.
He had been hospitalized.
He had been hospitalized.
The Friday before.
Yeah.
Yes.
I have
And
a question on the same topic, go ahead. So Dr. Singer was in the hospital on Friday, November 16th. The hearing was on Monday, the 19th. Is there any affidavit? I couldn't find that there's a note or a letter from a doctor saying that Dr. Singer was not able to attend the first hearing, because that's a question of due process presented by Counselor Bryan.
Yeah, if you look at pages 198 of your packet, you have Rabbi Mentz testifying in the hearing under direct examination by Mr. Mendez, and then the hearing officer interjects on the next page where there's talking about his anxiety, his fear of homelessness. I'm sorry, Ms. Bektesh, I misspoke earlier. There is mention of homelessness throughout this transcript. That's for your record at pages 198, 240, and 353. So here on 198, we have Rabbi Mentz testifying that the anxiety levels and stress levels sent his heart racing and put him in such a mood and condition that I feared for his life. And then Mr. Mendez asked Mr. Mentz, do you know whether Dr. Singer's ended up in the hospital because of these proceedings? Yes, he did. How long ago was that? It was a little while ago, relatively recently. Did you pick him up from the hospital? It goes on. Then Mr. Ireland intervenes and asks a clarifying question. And then if you go on to pages 240, this is when Dr. Singer himself, who's a retired ophthalmologist, medical doctor, says that I would try to mend my emotional ways, and at this moment, I'm a tremendously fragile individual, and I'm seeing a psychiatrist and a psychologist. Also, to your previous question, that's page 240. And I'm on medication. So I'm trying my very damnedest to do the right thing, as I've always tried to do through my life. And as, if you know, if APCHA has, if they ever had a specific complaint other than the dog being not on the leash, I would be happy to work with them on that and respond to whatever was going on. As far as my harassing people, I almost never went to the office. I did have an episode where I was in the bathroom and I had a herniated disc in my spine. It goes on and on. So if you read the transcript, which I hope you all do before you vote on this, this is laying out the testimony where I think, contrary to what Mr. Smith is saying, Dr. Singer expressed remorse and tried to explain his actions. Now, I do have a couple, I did say 5 minutes for rebuttal, so unless there's any other questions, I'd like to be able to do that.
Sure, of course.
Okay. Mr. Smith says that I'm saying that you shouldn't follow U.S. Supreme Court law. That's not what I'm saying. I'm not saying that Supreme Court law doesn't matter. I'm saying that case is different because that's where Congress passed a statute that put a 120-day period on things. And then the Supreme Court said, well, because of the way they wrote the statute, if you go beyond that agency, there's no penalty there. Here, it's very different. You yourselves adopted a rule that says your hearing officer has to get you written rulings within 30 days of the conclusion of a hearing. I don't know why your hearing officer took 135 days. But I know that he did not comply with your rule. And so if you're going to disregard those rules, which other rules? Please tell us. What other rules from APCHA are optional? Which other regulations can we say, well, that's advisory, it's not really mandatory. It's written in the regulations that it shall. It says must. But we don't have to follow that. Tell us, tell the community which of the APCHA regulations are not binding. Otherwise, don't write them down as being binding. Right? Okay. Now, he says that Mr. Smith said, nowhere in the transcript is there a statement that I want to know where in the transcript, and he could not find it. Mr. Smith wants, where he says that there's a statement that they did not intend to appear at the hearing. He could not cite that for you.
It's on 619.
619?
Yeah.
That's not in the transcript. That is an attachment to a brief that APCHA's lawyer submitted. That's not in the record. It's in your packet tonight. That's not in the record below. Ms. Johnson will set you straight on that if you need further clarification. But Mr. Smith attaching a document to his legal brief is very different than what the hearing officer considered. And by the way, going to the ER is going to the hospital. There was never a death threat made. That was hyperbolic. On April 7th, after a notice had been posted, Dr. Singer was worried for his life. And by the way, the allegation of criminal harassment, that was dismissed. So he can throw around terms like criminal harassment and arrest, but as you know, under the Fifth Amendment, due process, you're innocent until proven guilty. There were no criminal proceedings there. It was dismissed, not pursued. So, look, I think you have a lot of different ways to resolve this. One thing that I think you really should think about, let's go back to big picture. We can get real granular on this particular matter, but you should also be thinking about the big picture here. Your lease, at least for this matter, the August 2021 lease does not comply with federal law, and you should talk to your attorneys about doing that. Federal law states that the lease must include a description of APCHA's policies for selecting a hearing officer. Now, Mr. Smith tries to shade that a little bit by saying, oh, well, it's in the regulations how we choose it. It's not in the lease. That's what federal law requires. And federal law does not allow month-to-month leases. We never heard a good explanation for this. APCHA says that it's no big deal because it only applies to the lease term, and the question is to whether he's entitled to a lease at all. That ducks the question. Your lease is not to be month-to-month under federal law, and it is. And so we've got another violation there. I really hope that this whole episode can be passed and we can move on and everybody can be peaceful. I enjoy the pro bono work I do for Alpine Legal Services, but I really don't want to have to bring a lawsuit on Dr. Singer's behalf. I don't want there to be more contention among this community. I don't want there to be more derision. I don't want Mr. Smith to have to bill APCHA to defend this lawsuit. I want you to recognize the 5 or 6 or 7 or 18 different ways I've given you as a legal basis to hang your hat to grant this appeal. Thank you.
Thank you. Tom, you've still got about 9 minutes if you have anything you want to respond to. Or Kelly, I don't know if you had a question first.
Yeah. Tell me if I'm out of bounds, Kate. I guess I just want to clarify that's like sort of a minor detailed point of whether that email exchange is in the record or not about attending a hearing to create the record that's before us today.
I think
So if the hearing officer and all the parties were on a same email about a hearing, that is the record that we're reviewing. I'm not clear how to include or exclude that piece.
Well, I think we need to review the record, but if anybody, if staff can point us to the right direction, I think it would be appropriate for them to do so.
Well, it's
I
in
would-
there and it's dated the days
was-
prior to the hearing with all the parties of the hearing.
Right, it was attached, as I understand it, to Mr. Smith's argument, a brief, but I think there was a lot of discussion about it too on the record potentially before the hearing officer. Is that accurate?
If I can, you want me to address it? At the first day of the
I'm just not
hearing,
sure how to treat it.
I'd just ask you to look at the discussion, at the beginning of the hearing, when Mr. Mendez asked for a continuance, and the email exchange that had occurred on the prior Friday was referred to. Are those specific emails contained in the record that was presented to you? No. Were they an exchange among both parties and the hearing officer that everybody was on notice of? Yes. I mean, in their notice of appeal, they attached some documents that were exchanged. I don't care. All right? So it's up to you. But I think the record speaks for itself that Dr. Singer had already decided not to go. There's no medical report. Yes, there's anecdotal information that Dr. Singer was advised to rest and that the hearing was stressful. Well, I'll concede, I'll admit that the hearing was stressful for me too. It's stressful for everybody. Is that a medical excuse?
May I ask a different
And
question?
it's
Yeah.
on, just for your
Yeah.
knowledge, there's some information on page 48 and 49 of the record where Mr. Mendez does in fact ask for a reasonable accommodation on the account that Dr. Singer cannot be here.
And that's the hearing transcript of September
That's the hearing.
19th, yeah.
Yeah.
Thank you. I'm sorry, what's your name again, Mr. Mendez? Okay, and Chris,
Milton,
right?
Tony.
Thank you, okay. Kate, jump in if this is inappropriate, but is there specific objections to the conditions of the order that you made in your appeal that you want to call out for our attention?
Are there objections to the conditions that the hearing officer attempted to impose?
Yes.
Well, our objection and the basis for our appeal is that the order is void ab initio. So for the many legal reasons we've laid out,
That's fine.
you don't
That's
care
a
about that.
Good enough answer. I just wanted to know if you had specifically called out, like, we object to this condition, that condition.
Well,
specifically.
I don't, I'll say this, I think that itself might be in excess of jurisdiction for the hearing officer. I don't know where in APCHA regulations he's allowed to make the type of conditions that he did. So to the extent that he went off the reservation on that, that's another example of him exceeding his jurisdiction and doing something willy-nilly outside the scope of your regulations. Now, look, if you want to give your hearing officer free rein to create conditions and things like that and try to fashion these equitable remedies, put it in your regulations. If you don't want your hearing officer to have to give you written rulings within 30 days, take that out of your regulations. But the problem I think people have with the way they perceive some APCHA proceedings like this is that there's things in your regulations that you don't enforce, but then you want to get really strict on certain things. Now, that feels like selective enforcement to this community, because you're saying the hearing officer doesn't have to follow the 30-day thing, but then Dr. Singer's going to lose his house, his residence, based on a isolated incident. So
Well, we
put
haven't
in
said
your
anything
regulations.
yet.
Put in your regulations what you want. You get to change your regulations. So I encourage you to really look at those. And if you want hearing officers to be able to fashion the equitable remedies that this hearing officer purported to do, give him that discretion. But I don't see how he has the basis to do that.
Okay, thanks, Chris.
Can I finish now?
Yeah.
We're not arguing for the enforcement of that. They didn't do what he suggested as a way of avoiding immediate termination of the lease. He didn't do it. We're not asking you to impose it. We're not defending his decision to offer that option. On the question of the emails that I attached, this is specifically referred to, it's on page 50 of the transcript of that day's hearings. And I stated to the hearing officer last Friday, he said that he and his client weren't even going to attend this hearing because they didn't like the process. And I don't believe Mr. Mendez said that I was wrong about that. They're really going after this 30-day rule thing, as you can hear. And it's, I think, pretty obvious, because if you say they're right, then that's it. It's a legal question, all right? The facts aren't in dispute on that. It's a legal question. And I would encourage you to have Kate take a look at that issue. There's a lot of case law following that Supreme Court decision. Okay? The fact of the matter is that's a rule that's followed by the courts and agencies all over the place. It's not analogous to other. It doesn't mean if you follow the precedent and say, because no consequences are attached to that, we're going to follow the precedent of the Supreme Court. It's a procedural question, and like I said, what do you do? Start over? Who gains? Right? There was no prejudice from the delay. That would be a different question. If Dr. Singer lost his lease because of the delay, that would be a whole different case. And similarly with the denial of the continuance, all right? Dr. Singer wasn't required to present his case in the normal course by being first and having to present the case that day. None of his witnesses were required to testify, and none of them did. All he missed was listening. All he missed was listening, and his lawyer was there on his behalf. When it came time for him to present his case, he did it, unaffected by the fact that the continuance had been denied on the first day. I think we have to look at substance and not form on some of these issues, and that's what the courts do. I don't have anything.
I will say this, there was prejudice to his not being there. When a person's accused of something, whether it be an administrative hearing or criminal proceeding, they have the right to aid in their own defense, and that means hearing things, listening, being able to participate, meaningfully conferring with their attorney at those proceedings. That is the prejudice. And Mr. Smith forgets that there are two types of due process. There's procedural due process, what he calls form, and there's substantive due process. Those are both constitutionally guaranteed under our 5th and 14th Amendments. Both of those things were violated here. Colorado case law says when you sit in a quasi-judicial proceeding like this and you find that there was a violation of due process, whether procedural or substantive or both, that's a grounds to grant the appeal. So Mr. Smith can try to minimize the procedural defects here and call them just form, or they were meaningless, or there was no prejudice. The prejudice was in the denial of the due process itself. It's process, same root word as procedure. By not granting that continuance so that Dr. Singer could meaningfully participate in the hearing against him, where he could literally hear what was being alleged against him, so he could meaningfully confer with his Alpine Legal Services appointed lawyer, he was denied due process. That is the violation. That is the prejudice. And then there was prejudice by the 30 days. This has caused Dr. Singer significant stress not knowing what was hanging in the balance. So if the 30-day thing doesn't matter to you, delete it from your regulations. Otherwise, hold your hearing officer's feet to the fire.
Thanks, Chris. Any other questions for clarification? If not, I think the board is going to go into executive session for, we'll look for a motion to go into executive session for legal advice.
May I make a point of order?
Sure.
In executive session, will there be deliberations about the proceedings, or is it just
There will
as to
not.
guidance?
No deliberations will take place during executive session. It's just guidance.
So
legal
Thank you.
advice.
Just for clarification, you're asking guidance on some of the legal arguments that have been made and,
Yes.
and the legal basis for those arguments? Okay.
Carson, if we make that motion, should we also suggest a future date to deliberate in public? Do you want to come out and deliberate?
Maybe
Well, I think if, and I think that it might be possible you want me to do additional research on some of the legal points
Okay.
and provide an opinion to you, which may take time.
I am not prepared to decide this tonight.
okay.
Yeah, I think the last hearing we had another 2 weeks in between.
Mm-hmm.
Your next meeting is August 2nd.
But,
You can put it on the August 2nd meeting.
Okay.
but as your attorney in this matter, I would like tonight to get some instruction as to what types of legal questions you have that are independent of the factual findings, you know, you need to make in this case.
Kate, I will note that you and I are in court together on August 2nd.
Oh,
Okay.
that's right, yeah, I can't do August 2nd.
Me neither.
Court goes till 4 p.m., really?
Can you imagine?
I didn't, actually.
Would be August,
was August
it would be
9th,
August
wasn't
16th then.
And I am actually out of town that date. I'm returning on the 16th, I believe.
So September 6th.
Can we do a special meeting specifically for this one?
I'm available August 6th. I mean, September 6th.
I'm available September 6th.
Or the 9th?
What
You know,
happens
and
till September
to the
6th?
extent
We
you guys
still
want to
sit in
set a
limbo?
special
I'm also
meeting,
here, so I'm
certainly, I
available
understand
September
timing
6th.
wise.
You're
That's
absolutely
a long
available.
ways.
We could do a special meeting.
Yeah, you
The thing
could-
of it is that if you do it on a Wednesday, that's the third, that's the second or the fourth, you're hitting Board of County Commissioners. So it's hard to change a Wednesday date to the fourth, to the second or the fourth Wednesday.
Fifth Wednesday?
And and so the 9th would be the second Wednesday for them. So, the only.
Or August 30th, because we do not have a meeting on the 5th.
Because there's 5 Wednesdays, we could do a special meeting on August 30th.
I'm available August 30th.
My birthday.
Oh, is it?
Happy
I was gonna
birthday.
Backpack.
I mean, that's
Maybe
just
I'm,
a
like,
week,
shooting
that's just a
myself
week
in the foot.
different from the 6th, or if Jim True could be with us on the 16th.
I was gonna say Jim could cover for me, I think. I don't see any issue with that. But
So then the 2nd.
Or the 16th.
the 30th, it works for me as well, either.
They-
Or the
oh, yeah.
16th.
For the
Chris-
record, I'm
Chris, can you
available
hear?
August
Sorry.
16th, August 30th, and September 6th.
My request would be the 16th, I guess, to not add another meeting.
So
September
August
16th.
16th,
September
August
16th.
August
16th.
16?
and then we'll,
Assuming
and
Jim True is available
Yes.
for.
Yeah, and actually, I actually think I fly home on the 15th, so I should be able to do the 16th. That's not a problem.
Okay.
I'm gonna add that to my
3 p.m.?
motion then.
Works for me.
we might start at our normal time, which is 4, because this may be the only thing that's on the agenda on the 16th.
That's fair. Okay.
But I'll make sure that everybody knows before next week.
Thank you.
Okay. Allison.
I'd like to make a motion to go into executive session for a conference with our attorney for the purpose of receiving legal advice under C.R.S. Section 24-6-402 4B regarding Dr. David Singer's appeal. Just for the purpose of receiving legal advice, we'd like to deliberate this matter further at our August 16th regular meeting.
So just for clarification, sounds like you're making two motions. One would be to continue it till August 16th, and then the second would be to go into executive session. Do you want to do the first, the continuance first, so that I think
Everyone can go.
Yeah, let's do that. Let's do that. So we have two motions. I need a second for continuance to August 16th.
I'll second.
Kelly, for the second from Kelly. Okay, Cindy, it's a roll call vote.
Allison?
Yes.
Kelly?
Yes.
Ward?
Yes.
Carson?
Yes.
John?
Yes, almost.
Okay, so we will
answered for the other guy.
continue deliberations on this appeal on August 16th.
Okay, thank you.
Thank you.
And then we have a second motion to go into executive session. Is there a second on that?
Second.
Second from Kelly as well on that one.
Clarification, August 16th at 4 p.m.?
She'll let
I'll
us know.
verify that, but probably.
I don't know, it's
But I
scheduled.
will verify that and let you know before the end of the week.
Cindy, will you send the email that you sent for this meeting with that
Yes.
whole group? Thank you. Thank you, everyone.
Did,
Thank
did you
you.
second?
Roll call?
Was my second?
I second.
Roll call vote.
Yeah,
Yes.
thanks.
Okay, I'm going to go backwards. John? Ward?
Yes.
Carson?
Yes.
Ward?
Yes.
Kelly?
Yes.
Allison?
Yes. Can we also have?
Okay. Thank you. We'll take a short break
Yeah, I think
here.
that would
There will be
be
no
okay.
further agenda items after the executive session.
Kate,
Yeah.
can we verify that this is Jim True?
Thank you.